All right, let's get on the record. This is cause number 645964, State of Texas versus Stephanie De Leon. We're on Zoom. Defendants present, defense counsel's present, state's present, and we're recording. I believe, Ms. Gonzalez, you have a motion that you wanted to present to the court on the record.
Yes, Your Honor. I actually have two motions. The first one is actually the easiest. It's the one that I just emailed to everybody. It's going to be the waiver of arraignment. My client was given a court date, and I want to say the court date is going to be February 3rd, 21st. And I believe that was actually given an arraignment setting. My client, at her direction, I filed this motion to waive the arraignment, and we would like to proceed to a trial setting.
Okay, I'm going to grant that. I'm going to go ahead and sign your email as soon as we get done with our hearing.
Okay.
And then everybody get a copy via email.
Okay.
What's next?
Yes, Your Honor. The next one is actually going to be the little bit more of a lengthy one. It is, I have titled this motion, the defendant's pretrial and trial requests and demands. And searching through the Code of Criminal Procedure, I identified 3 different issues where I laid out in this motion individually. The first one is going to be a request a demand for a speedy and public bench trial. My client, under the Constitution of the United States, as you know, has a right to a speedy trial. Because of the pandemic, I have already met with my client and I discussed all of her options with regards to everything and the approximate time I'm expecting the Bexar County Courthouse to resume jury trials, and the significant delay that waiting for a jury trial is going to cause. After explaining all of her options to her and different things she can look at, she has agreed to waive her right to a jury trial. She does wish to resolve this matter as quickly and as efficiently as possible. So she is asking that she be allowed to do a bench trial before the court.
Okay, Ms. Fernandez, any response to that first request?
At this time, the state is not waiving its right to a jury trial. We have no objection to setting this on one of the first jury trial dockets in County Court Outlaw number 7. We are waiting for further evidence to come in before making a final evaluation about how the state even wants to proceed on this case. But we are open to potentially changing our stance on the bench trial once more evidence does come in. But at this time, we are not waiving our right to that jury trial setting.
And Your Honor, if I can respond to that briefly.
Sure.
Just for the right, since we are on the record for clarification, I'm sure Ms. Fernandez meant that she has a procedural right to a jury trial, and it's to not approve my client's constitutional right to waive the jury trial. So that is actually if the state does maintain that they are not going to consent to a bench trial, I will be filing a speedy trial motion that I have drafted specifically with case law with regards to this specific issue. While this is a pandemic and a lot of this is going to be new materials and arguments that we're bringing forth, the arguments that I've researched and looked up actually have a basis in constitutional law from the 1950s from the Supreme Court with regards to this specific issue and whether or not that this refusal to consent to a bench trial is actually going to violate the district attorney's office obligation to use due diligence in bringing forth a case. So I do understand we're still in a position right now because the case is somewhat new. We're still in the position of getting some of the discovery, which I'm going to get to in the next paragraph. It's nothing that can't be done very quickly. And the burden that all of this is placing on my client, I'm going to be asking the court to look at whether or not the state has a greater procedural right versus my client's constitutional rights. And I do believe the Constitution and the Supreme Court and all of the case law that follows from it is going to say that my client has a greater constitutional right to be able to waive this jury trial. Furthermore, as I said, the pandemic, everything is still growing with the case law and arguments for this. Right now, there are federal cases and federal memorandums that have stated that the right to not approve a bench trial is actually not going to be enough. And the state, in 2 cases that I found, the state has been required to go ahead and do the bench trial because they cannot meet that burden, that it's greater, that right, that desire for a bench trial is greater than my client's constitutional right for waiving the jury trial. So just so the state knows, I will be drafting those motions and filing those very soon if that is the position they do want to maintain. And I will be asking for a hearing on that.
And Your Honor, the state has no objections to a status hearing, I guess as we want to call it, just to see where it is, because some of this discovery, which is in this specific motion we are talking about, is for defense's benefit as well as the state's before we can make a final determination. And at that time, we will give, or even prior to, depending on how fast this discovery gets in, because as Ms. Gonzalez says, there is a pandemic and our office is currently working on a rotating system with trying to get discovery uploaded still as quickly as possible for both sides. So I will be checking on that if we want to proceed with that way in order to assure a kind of stance on this so we can get the ball rolling, essentially.
All right, I was going to go ahead and suggest a status hearing after all this so that we can figure out where we're at. Okay, I mean, interesting argument. We'll deal with that if we need to down the road.
Okay, thank you, Your Honor. Okay, now this is going to be the bigger issue. Ms. Fernandez and I already spoke briefly before we went on the record. There's basically 2 categories of discovery that I am still looking for. One of which I think is going to be easily resolved once we get the information. She can go ahead and send it to the investigator. There is still an outstanding 911 call. I'm sorry, non-emergency call that was placed by my client at the Jack in the Box before the 911 calls that we already have in our discovery packet. We already have those calls. It does not address the 911, the non-emergency call that was made while they were at the Jack in the Box. That is the one I'm waiting for, and we should be able to locate that one. However, the second discovery issue is a little bit, I would say a little bit more in depth. By the research that I've done from the information I received in the discovery packet, is the victim in this case, his name is Kenneth Walters. While I did some preliminary information, I reviewed the 911 tapes where a comment was made by Kenneth's mother, Mrs. Donna Walters. She made a comment that led me to do a little bit of research on my own. And running Kenneth's SID number through CGIS, I was able to discover that he is actually currently on deferred adjudication out of the 290th for an assault bodily injury second case. Now, I do not have the indictment in front of me, which is one of the things that I'm requesting as part of this discovery under Brady request. I am requesting the offense report from this case. I'm requesting the indictment, the judgment, the conditions of probation. He had an MTR that was filed against him as of this spring, right before this offense allegedly happened. He had that MTR. He also had a that was adjudicated. I'm sorry, that was not adjudicated. The MTR was denied and he was continued on probation. After that, there was actually on, let me get the date, on May 12th, 2020, which is going to be, I think, 6 days after this alleged offense date, a supplemental violation report was filed against Mr. Walters. In the discovery that I have, he does not mention this alleged terroristic threat until we get to May 13th, which is 1 day after the supplemental report. That is the first time he makes this allegation of a terroristic threat. And I did forget to mention, but I think it's a pretty safe assumption. On March 22nd, 2019, I'm sorry, on, oh, where did it go? Yes, I'm sorry. On March 22nd, 2019, Ms. De Leon, my client, is actually listed as a no contact order with Ms. De Leon. So again, without the indictment or the offense report, it's just based off of what my client is telling me, but I think it is a very safe assumption for this court to make that she is the exact same person that is the victim in this case that he's on probation for out of the 399. That is Brady material. That is something that I will be discussing while I am cross-examining this alleged complainant as to whether or not he made up these charges to be able to get out of a potential second MTR. So I am asking for all of those listed things, and let me just check my list. I do believe that's all the things that I am going to need in order to cross-examine him. However, of course, once I review it, if anything else comes up, I will again be bringing a discovery request to this court.
Ms. Fernandez, any light you can shed on the status of your complainant?
So we have spoken with the complainant in this case, and he has told us that he will be non-cooperative with the state in this investigation, which is part of our review process. I'm trying to pull up our case right now and Mr. Walters at the same time. I'm trying to see, we did run an NCIC TCIC and saw this came up, and he did mention to our advocate, Rosalinda Perez, that he was on felony probation, which Ms. Gonzalez already said. I have no problems giving her the probation conditions and seeing if my investigator can bring up the offense report date, or if I can get it from JD from the felony indictments. I would have to see if I can get a certified copy via the 399, or just, you're fine, Ms. Gonzalez, with the PDF version. I can print off my system since I'm not the one who created the indictment or presented it to the grand jury myself. As for the MTRs, Your Honor, I think trying to go into more specific details of those MTRs, I don't think they're necessary as to go to his character, as besides having the judge. I don't know about the judgment, but the conditions of probation to show that he is in fact on probation, and Ms. Gonzalez already, once we get it and hand it over via Veripic or other ways of handing it to Ms. Gonzalez, having that offense report of the ABI second family violence. I don't think the MTRs are necessary for her to proceed, especially since he has already told us he is non-cooperative with the state in this case. So we don't even know if we are to proceed to trial, and that's an if he would even come in, even if we subpoena him. But we have no problems giving an offense report over in probation conditions and an indictment in that case.
Ms. Gonzalez mentioned a May 13th, 2020 date where apparently the complainant made an allegation of terroristic threat by this defendant, Ms. De Leon. I think that'd be highly relevant to the defense's ability to know what's going on with this defendant.
Your Honor.
If he were to testify, if he were to show up to court.
Right, so we are unaware of that until right now. We were going to ask for clarification if that terroristic threat is this one, because this date is in May, but I think you said March. So I was asking for clarification if that's a reasoning for that MTR being triggered, or if that's the new number one, or if that's any number one as into this terroristic threat.
So the pertinent dates with regards to this issue is that he received an MTR on February 4th, 2020, which is precedent to this complaining date. He received that MTR. That MTR was actually adjudicated, and I believe Mrs. Walters makes a comment when she speaks on 911 about the fact that she was upset because her son just got out of jail due to Miss De Leon. So it's going to go to whether or not he has motive to lie. Furthermore, he was continued on probation on April 16th, 2020. I believe our offense date is going to be May 6th, 2020. And the 2089, which is the first time Mr. Walters makes mention of an alleged terroristic threat, is on May 13th. And that date is one day after a supplemental report was filed against him. There was a supplemental report filed on May 12th. So I need all of this stuff to be able to look at Who did he talk to? Who did he let them know that he was actually with Miss De Leon at that time? Was it a condition of his probation that he was not to be around her? Now he's going to try to play a victim card and say, oh, she threatened me, and try to use that to possibly escape in a second MTR. I don't know this for sure. I completely admit that. However, this is highly relevant to my being able to prepare for Miss De Leon's defense.
Right, and if you could just maybe email me that date after this hearing again, so I make sure I wrote it down correctly, because the only mentions of a terroristic threat the state has, Your Honor, is this pending case in May, which is why we were not aware of a March, and that's again because felony has not reached out to us about anything and we had no information, but we are happy to provide at least the felony information for Ms. Gonzalez to prepare for her case, since we do agree it goes to the relationship between the two parties.
And as far as a March date, the only March date that I was referencing was back in 2000, I think 18 or 19, when he originally got arrested for the offense. She was the subject of a no contact order.
Yeah, so you're saying that she was the complainant in that assault second felony.
Correct.
Yeah.
Again, I haven't seen the indictment, so I can't say that for 110% sure, but that's what Ms. De Leon tells me. That's what the 911 mention is about. That's the way it appears on CGIS when I look it up.
All right, well, right now, number one, I mean, all of this is a deferred adjudication for Mr. Walters, so that wouldn't be relevant at trial. However, I'm sure Ms. Gonzalez will argue there are some hearsay exceptions where this might come in. So state, can we agree that you're going to get Ms. Gonzalez the offense report, a copy of the indictment, any type of judgment? Doesn't have to be certified, does it, Ms. Gonzalez?
I don't think so. I don't think the court would have a problem if we are taking judicial notice of it. I don't think it has to be certified.
Exactly. There's no need to certify that. And I think you said conditions of probation, right, Ms. Fernandez?
Yeah, I definitely do need that, because I need to know if he's been told he still has a no contact order with her. That's going to be relevant as to, and again, I'm not talking about for character. I understand about the limitations of character. I'm wondering if whether or not he has a motive to lie to make up charges.
Okay. So, Ms. Fernandez, those 4 deals, 1, 2, 3, 4.
I will make the request appropriately after this hearing. So yes, I have the offense report, a copy of the indictment, which will be just what I have Ms. Gonzalez under my system, which will not be a certified copy from the clerks from the 399th, if that's okay with you.
That's fine.
And the judgment, and then the conditions of probation for Mr. Walters on that cause number, which for the record, what I'm pulling up is 2019 CR 2103, the assault family second out of the 399th District Court.
Ms. Fernandez, let's also make sure that you get the probation officer's name for Mr. Walters to turn over to Ms. Gonzalez, because that may be necessary down the road.
Yes,
correct. And then Victoria, did you also list off the copies of the supplemental report so I can see if they were saying that he was with her, that he violated a no contact?
You mean supplemental offense reports?
No, the supplemental violation report.
We did not go into the MTRs at this time since he's still on deferred, and judge had only listed those 4 documents.
Well, that's what I'm saying is because if he met with his probation officer and his probation officer says, you have violated your conditions of probation, I'm going to file against you, that goes to his motive to lie. That's why I'm looking for the supplemental reports.
I would argue, Judge, that's a little bit of a stretch since those are dates prior to this terroristic threat, and that in the conditions of probation, there would be the listed, whether it's no contact or no harmful injurious contact. And so even with them in this pending case in CC7, with them being together, if there is in fact a no contact order, then it shows that there's a violation.
No, the supplemental report is noted in CGIS as being filed on May 12th, 2020. So that's 6 days after the offense date and 1 day before he fills out his 2089.
I have that as being held in abeyance. I don't know if there's a report, but Your Honor, if you want me to look into that, I can try. I just feel like we're getting out of the realm of whether or not any of this will go to showing whether this terroristic threat happened on this date in regards to Ms. DeLeon's case, and that the state will eventually end up going on a fishing expedition of some sort to get everything in relation to these two parties.
Sounds good. Well, Ms. Gonzalez, it seems like you know that you made an allegation of terroristic threat on May 13th, 2020. Let's just get you the officer's, the probation officer's name right now.
Okay.
And if we have to revisit that issue down the road, we will.
Okay. I'll circle that as revisiting.
Okay.
Yes, I will get started on those 4 items in the 911 call. And then Ms. Gonzalez, I have checked with my paralegal because she's with us in CC13. The requests are kind of long, but she is working on the COBAN to be uploaded as well for this case. So hopefully by the end of the week, you'll have it. Please let me know if you don't.
Was this an arrest case or at large?
This was the confusing at-large case that was filed back in September. My client was actually arrested on May 6th for the offense of criminal mischief, and then the terroristic threat case was filed at large against her. Let me pull up that date. That was filed on May 15th, 2020. So the prosecutor in the criminal mischief case went ahead and dismissed the criminal mischief on September 3rd, 2020 as restitution paid in full, and filed this terroristic threat case simultaneously. And then a warrant got issued, and then I had to contact the court to get on the case last minute and get that warrant withdrawn.
How much time do we need to get all this information over to the defense?
I would say about 30 days.
48 hours?
You're asking for a miracle from me, Judge. Just because I need to be slightly more specific with the 911, COBAN's being worked on, and then me going to the felony courts for this. If it's for the evidence, I would say about 2 weeks. It's for a status check on the state, whether we're going to proceed, like how we're going to proceed with this case. I'd ask for at least no more than 30 days, and I should have an answer maybe even before that. So if we just want to wait for the 30 days for everything, that's fine. But if you want an evidence check in, about 2 weeks.
How about we split the baby, make it 3 weeks?
That's fair.
1, 2.
I'm looking at November the 4th, around there, Your Honor, about 3 weeks.
Yeah, we're typically doing things on Mondays and Wednesdays. Let's do the 4th then. Sound good, Ms. Gonzalez?
Yeah.
That works for me, Your Honor.
Okay, let me put it in my phone here so I don't forget.
That alarm.
And if the state has an update even prior to that, we'll make sure to email all parties in the court.
Thank you.
Okay. All right, it's on my phone. It's official.
Thank you.
And then Ms. Gonzalez, just to clarify for your motion, because there is a mention of the of a request for the information or indictment. Is that also for this case, or are you more specifically for Mr. Walter's case?
No. So this is the third one, which I should probably move to the first one because it is actually the easiest request. I just need a copy of the information that was filed on this terroristic threat case. I just need my copy of the information. This should now be much easier because I've been told by the supervisors in the county clerk's office that she has directed all of her clerks to go ahead and email those to us. But when I first started filing these, the clerk's office was requiring a judge's order that they had to do what was already ordered to them by the Texas Code of Criminal Procedure.
Okay.
So
let me know if you're having issues, and I'll give you a state's version of it like I will with the indictment.
Okay. Sounds
Granted.
good.
Sounds good.
Okay, so do you have the motion to be able to sign with our agreements or dates, Your Honor?
I do, and I'm going to sign it, and it's going to be sent back out to everyone.
Great. Thank you so much.
Good. Anything else we need to?
Nothing from the state.
All right, sounds
Nothing
good.
with regards to this case, Your Honor.
All right, Ms. De Leon, B, you're excused. Stay in touch with your attorney, okay? And
Okay.
stay out of trouble.
Yes, sir. Thank you.
Thank you,
Thank
ma'am. You're
you, Stephanie.
excused.
Bye.
And we're off the record.